Good evening. Am I audible? Hello, Pratyusha. Hello. So we'll just wait for 2 minutes and then we will start. Hello, Prerna. Hello. Hello and good evening, all of you. So, we have a special announcement to make. So, we are offering a 20% discount. Yes, 20% discount on the subscription, which is which was only for yesterday and today. So, you get a 20% discount on all the subscriptions if you use the code Yashas Live. YESHASLIVE, Yashas Live. So use the code Yashas Live, YESHASLIVE, to get the 20% discount. So CA Iconic program, which is the flagship program of the Unacademy, flagship program for the CA Foundation aspirants. So what do you get in this? In this flagship program, what do you get? We have a live mentoring platform in this Iconic subscription. So what is this a live mentoring program? So you have a one-to-one personal coaching, one-to-one doubt solving, evaluated test series, printed books, industry experts, um, in industry expert session, plus live classes, weekly tests, study materials, unlimited access, and structured courses. One-to-one live mentoring course which has already been launched. So what is there in this? You experience personalized learning like never before with our seasoned mentors. You discuss your doubts and clarify your concepts and enhance your exam strategies. You get customized, yes, you get customized study plans which suits your purpose from dedicated mentors, and also articleship guidance to help you through your articleship period and your professional world. We have also launched the evaluated test series. So these test series are conducted in three parts, where the first one is a 40% syllabus, the second one is a 80% syllabus, and the third one is a 100% syllabus coverage. And we also, along with this, we have an analysis class with a detailed evaluation of the exam. and also an evaluation of your answer scripts, as in what was good in the paper and what could be improved. So this iconic subscription we have for the CA Foundation, which is for 6 months, 12 months and 24 months. The 6 months is for 25,000, that is 4167 per month. 12 months is for 35,000, that is 2917 per month. And the 24,000 is 24 months is 58,000, that is 2417 per month. Use the code YESHASLIVE, YESHASLIVE, YESHASLIVE to get the subscription. We also have a combo subscription for both the foundation and the intermediate, which is the iconic subscription. It has we have two options here, the 12 and the 24 months. The 12 months is for 49,500, that is 4125 per month, and the 24 months is for 66,000, which is 2750 per month. Use the code YESHASLIVE, YESHASLIVE to get the subscription. So last class I think we had discussed till communication and revocation, right? If I'm not wrong, last class we had discussed till communication and revocation, correct? The last class we had discussed till communication and revocation. Put the phone on charge, otherwise my chats will stop with you all. Yes. Okay. So today we will start with the chapter consideration. When we say consideration, when the whole concept of a contract, one of the foundations of the contract is that when I give you something, I should get something in return, right? When I give you something, I should get something in return, and what I get in return is my consideration, right? When I give you something, I should get something in return, and what I get in return is my consideration. Technically, consideration is known as quid pro quo, right? Consideration is technically known as quid pro quo. Quid pro quo. And what is quid pro quo? It means something in return. It does not mean, I repeat again, it does not mean anything or everything in return. It does not mean anything or everything in return. It means something in return. That means when I give you something, I should get something in return, and what I get in return is my consideration, right? And what I get in return is my consideration, something in return, quid pro quo. In fact, if consideration is not present, it is void. The contract is void. In fact, if consideration is not present, the contract is void, right? If consideration is not present, the contract is void. Now, what is consideration? As defined under the Indian Contract Act, Indian Contract Act, consideration, what does consideration mean? When at the desire of the promiser, right? When at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other, right? When at the desire of the promiser, the promisee or any other person had done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. So in fact, if we actually analyze this definition, we get a lot of things to learn from this definition itself. So what are these things that we learn from the definition? The first thing is that consideration must move at the desire of the promiser, right? The first thing that we learn from here is that consideration must move at the desire of the promiser. However, consideration may move from the promisee. from the promisee or any other person. Right? Consideration may move from the promisee or any other person. Again, consideration may be past, present, or future. And each act or abstinence form consideration for each other. That is, my act is your consideration and your act is my consideration. Or my abstinence is your consideration and your abstinence is my consideration. Or my act is your consideration and your abstinence is my consideration. It could be either ways. My act, we both have act and my act is your consideration, your act is my consideration. We both have abstinences. Abstain means or abstinence means to not do something. We both have abstinences, so my abstinence is your consideration and vice versa, your abstinence is my consideration. Or I have an act, you have an abstinence, so my act is your consideration, your abstinence is my consideration. Or vice versa, I have an abstinence, you have an act, so my abstinence is your consideration and your act is my consideration. So if you remember, I had given you that example also, car and price. I have to give you car, you have to give me price. So car is my act is car, which is consideration for you. Your act is price, which is consideration for me. Right? Right? So I hope this definition is clear. Can we now move to the next part? So if we look at the rules, the first rule says, consideration must move at the desire of the promiser. Right? The first rule says consideration must move at the desire of the promiser. Right? So when I am doing the work for you, right? When I am doing the work for you, and you have never asked me to do the work, can I sue you for consideration? No. When I am doing the work for you, but you never asked me to do the work, can I sue you for consideration? No. I can sue you for consideration only when you have asked me to do the work. Right? I can sue you or I can ask you for consideration only when you have asked me to do the work. So the desire that the work should be done must be there for me to claim that consideration. Again, you have not asked me to do the work. Can you sue me to do the work which I fail to do? No, because consideration must move at the desire of the promiser. So unless the desire of the promiser is there for the work to be done, we cannot hold the promiser responsible for not doing the work. Unless the desire of the promiser is there to do the work, we cannot hold the promiser responsible for not doing for the consideration. So if he desires, only then I can hold him responsible for the consideration. However, the second rule says consideration may move from the promisee or any other person. That is, even if the promisee is not doing the work, even if a third party does the work, it's absolutely valid. The whole point is consideration must be present, but who gives it is irrelevant. The whole point is that consideration must be present. Who gives it is irrelevant. Hello, Mahalakshmi. So, consideration may move from the promisee or any other person. So, what the point here is that consideration must be present. However, it is absolutely irrelevant who gives it. So, you give or someone else give doesn't make a difference to me. If I am getting the consideration, it is enough for me. It is enough for me. So, if I sum up the two rules, the desire of the promiser should be there. But instead of the promisee, if someone else gives me the consideration, it's absolutely valid. Right? The desire of the promiser should be there. But instead of the promisee, if someone else gives me the consideration, it's absolutely valid. Consideration should be there. It is irrelevant who gives it. So we had discussed this case that you want to sell your phone to your friend, right? And if you remember, from consideration point of view, we both are the promiser and promisee, right? If you remember, I told you from consideration point of view, we both are the promiser and promisee. So from U's point, you are the promiser, F is the promisee. From F's point, F is the promiser, U is the promisee. So from U's point, U's desire should be there that he wants to sell the phone. And from F's point, F's desire should be there that he wants to buy the phone. Right? Now, instead of you, if your brother hands over the phone to your friend, is it valid? Yes. Because for F, the consideration must be given. You give or your brother gives makes no difference to him. Now, instead of your friend, if his mother pays you, is it valid? Yes. From your point of view, you should get the money. Your friend gives or his mother gives makes no difference. The money should be given. That is what makes a difference. So, consideration may move from the promisee or any other person. Right? So, this was kind of a summation of both the points. And on this grounds, we can say that there can be a stranger to consideration, but not a stranger to a contract. Right? There can be a stranger to consideration, but not a stranger to a contract. As in, a third party can give consideration, but a third party cannot enforce the contract. As in, a third party can give consideration, but a third party cannot enforce the contract. Right? Now, the next one, consideration may be executed or executory. Executed means an act already done. So, if a party has already performed his part, his act is executed. Executory is an act yet to be done. That is, promise is made, but it is yet to be done. Right? Promise is made, but it is yet to be done. So let us say the classes are going to start after 20 days. You have already taken the subscription on Unacademy. Right? You have used the code Yashas Live, YESHASLIVE. You have used the code Yashas Live. You have already taken the subscription. Right? But the classes are going to start after 20 days. So can we say your act is executed? Yes. But Unacademy and Yashas Academy act is executory. Now again, consideration may be past, present or future. What is future will be done. What is present going on? What is past? Previous request and subsequent promise. First, there is a request for the work to be done. Then there is a promise to pay. Right? What is past? Previous request and subsequent promise. First, there is a request for the work to be done and then there is a promise to compensate. Previous request and subsequent promise. Right? Then again, in every contract, consideration must be present. Right? In every contract, consideration must be present. However, there is no rule which says that consideration must be equal. In every contract has to be supported by consideration, because if there is no consideration, the contract is void. Because if there is no consideration, the contract is void. We already established this, that without consideration, the contract is void. So consideration is something which is mandatory for a contract to be valid. So if there is no consideration, the contract is not valid. So if there is a contract, there has to be consideration to make it valid. However, what the rule says is that consideration must be present, but there is no rule that consideration must be equal. Right? Consideration must be present, but there is no rule that consideration must be equal. That is, give and take should be there, but there is no rule that give and take should be equal. Right? Give and take should be there, but there is no rule that give and take should be equal. And just because one party is getting more than the other does not mean that the contract is not valid. So a contract cannot be cancelled. I repeat again, a contract cannot be cancelled on the grounds of inadequacy of consideration. That is, inadequacy of consideration is not a justified ground to cancel the contract. Then, if a person is already receiving a legal fee, right? If a person is already legally bound to do some work, if a person is already legally bound to do some work, and for that same work he is already receiving a legal fee. If a person is already legally bound to do some work, and for that work he is already receiving a legal fee, and for that same work if I pay him something extra, then that extra is what? It is void. That means if I promise to pay him this extra and then I later refuse to pay him this, he cannot sue me to recover it. Or if I have paid him and he does not do it, I cannot sue him to recover the money back. This extra is void. That means what? If a person is already legally obliged to do something, I am not responsible to pay him any consideration. And if I pay him any consideration, it's not valid. But if a person is not obliged to do something for me and for that I pay him some consideration, then that is valid. So I repeat again, if a person is already legally obliged to do some work for me and for that I pay him consideration, it's not valid. But if he is doing something which is outside his duty and I pay him consideration for that, then that extra is valid. I hope it's clear. And there is one last rule which says consideration must not be unlawful, illegal, or against public policy. So it should be within the legality. It should not be unlawful, should not be illegal or against public policy. So we are done with the rules of consideration. I'll just give you 2 minutes. If you have any doubts in any of the rules, you ask me. Otherwise, we'll go to the next topic. So I guess no doubt. So we'll go to the next topic. So moving on to the next topic. Privity of contract. Now, what does privity of contract mean? Privity of contract says a third party has no right to sue on the contract. In fact, I just told you there can be a stranger to consideration, but not a stranger to a contract. That means there cannot be a third party to the contract. To put it in very simple terms, there is a contract between X and Y, right? There is a contract between X and Y. Now, if Z wants to sue on this contract, can Z sue on this contract? No. No. Can Z sue on this contract? No. No. Why? Because X and Y can sue each other, but Z is no one to enforce this contract. This is what we mean by privity of contract. Only the parties to the contract can sue and be sued, third party cannot sue. So if you are a party to the contract, you can enforce the contract. But if you are not a party to the contract, you cannot enforce the contract. Only the parties to the contract can sue and be sued. Third party cannot sue. Right? Third party cannot sue the contract. लेकिन law में क्या होता है? लोचा. So there are cases where a third party can sue. So there are cases where a third party can sue. What are the cases? The first one, if in a contract, okay, if in a contract you are named as a beneficiary of a contract, if in a contract you are named as a beneficiary of the contract, so when you are named as a beneficiary of the contract, you are entitled to get the benefits of this contract. So when I say you are entitled to get the benefits of the contract, that means you are supposed to receive them under the contract even if you are not a party to it. Now, even if you are not a party to it, you are supposed to receive the benefits, but if you don't receive them, you can go and sue the contract. So even though you are not a party to the contract, you are entitled to the benefits. And if you don't receive these benefits, you can enforce the contract. If you don't receive these benefits, you can enforce the contract. If a person is named as a beneficiary in a family settlement, in any family settlement like wills and all, in any family settlement or in any family disputes are going on, if a person is named as a beneficiary, excuse me, even if the person is not a party to the contract but he is named as a beneficiary, right? There is some family dispute, the disputes are settled, the properties are partitioned, anything. And if a person is named in that family settlement as a beneficiary, even if he is not a party to the contract, he has a right to enforce the contract. Even if he is not a party to the contract, he has a right to enforce the contract. Same thing is in the case of a marriage settlement. In case of any marriage settlements, if any person is named as a beneficiary, so for example, if the wife is named as a beneficiary in any marriage settlement, so in that case, even if she was not originally a party to the contract, being a beneficiary of that marriage settlement, she has a right to enforce the contract. Assignment. The word assignment means transfer of rights. In every contract, a party has to give something and a party has to get something. What the party has to give is his liability. What the party has to get is the right. Right? What the party has to give is liability. What the party has to get is rights. Now, if these rights, if the party who is supposed to receive the rights, who is entitled to the rights, transfer these rights to someone else, to a third party, this is assignment. Right? If the party who is entitled to receive rights under the contract transfers these rights to someone else, this is known as assignment. Right? This is known as assignment. Now, in case of assignment, I repeat again, in case of assignment, when we talk about assignment, in case of assignment, when the rights are transferred to a third party, the third party is obviously not a party to the contract. The third party is obviously not a party to the contract. But since the rights of the contract are assigned to the third party, he will now get those rights. And if he does not get those rights, he can enforce the contract. If he does not get those rights, he can enforce the contract. Then the next one is topple or acknowledgement of liability. If a person acknowledges himself to be liable to another, if a person acknowledges himself to be liable to another, then even if there is no contract between the two, the person who has acknowledged his liability can be sued. If a person acknowledges his liability to another, right? If a person acknowledges his liability to another, then in that case, even if there is no contract between the two, even if there is no contract between the two, then the person can be sued because he acknowledged that he was liable. So you have seen in all of these cases there is no contract, but still the party can be, there is no contract with the party, but still the party can sue. And the last one, in case of covenants running with the land, basically covenants, that is agreements running with the land. So when a purchaser of the land, he buys any land subject to any agreements. Okay, when any person, he buys any land which is subject to any terms or any agreements, and he knows about those agreements. So when he purchases the land, he also is bound by those agreements. And if he fails to fulfill those agreements, the person who is named as a beneficiary of those agreements can enforce the contract. When a purchaser of the land purchases any land, then in that case, subject to any terms or conditions, then in that case, he is also bound by those conditions. And in that case, if the third party who is named as a beneficiary in this land, if he does not get the benefits, he can even enforce the contract. Is it clear to all of you? Is it clear to all of you? So we have done this topic. I'll just give you 2 minutes again. Just go through it if you have any doubts in any of it. Otherwise, we'll go to the next one. In case of an agency, if the agent, if let's say the agent contracts with the third party in the name of the principal, the contract is between the agent and the third party. Principal is not a party to the contract, but he can still enforce the contract. So if the third party fails to perform, the principal can sue this contract to enforce the contract. Done? Now the next one, we already discussed that an agreement without consideration is void. Right? We already discussed that an agreement without consideration is void. However, law में क्या होता है? लोचा. So a contract without consideration is void. Generally, a contract without consideration is void, but there are some cases where a contract without consideration is absolutely valid. So what are these cases? The first one, natural love and affection. So obviously some conditions have to be fulfilled to make it valid. So when out of love and affection, two parties, they stand in a near relationship, right? When out of love and affection, two parties stand in a near relationship, so there has to be a relationship, enter into a contract and get it written and registered. So the key point is written and registered. It's a valid contract. So when it is out of love and affection, the parties are in a relationship, they enter into a contract and the contract is written and registered, right? It's a valid contract. So if it is written, and please understand, all these points have to be fulfilled. So even if one of the points is missing, it is not a valid contract. So if it is written and registered, if it is out of love and affection and it is between parties who are in a relationship, it is a valid contract. Then compensation for past voluntary services. From the name itself we get it. The services were rendered voluntarily. The services have already been rendered and the promiser promises to compensate. It's a valid contract. So services have been rendered voluntarily. The services had already been rendered. Promiser was in existence. That means he was there when the services were done and he is there when the promise to pay is made. He should be there at both the times, existing. This point generally is for artificial persons. And he promises to compensate. It's a valid contract. Right? So if you help someone and he says, oh, such a good person you are, thank you, go. Will you get anything? You will not get anything. But if he promises, I will pay you, then you will get. Right? Then time bar debt. A time bar debt is a debt which is irrecoverable by law. That is, under the Limitation Act, if 3 years have lapsed from the day it was repayable, it becomes time barred, that is irrecoverable by law. Now, if a person gives a written promise to pay a time barred debt, right? If a person gives a written promise to pay a time barred debt, it's a valid contract, right? If a person gives a written promise to pay a time barred debt, has to be written. So here again, it's a written one. If the written promise is for the whole amount, it's valid. If the written promise is for a part of the amount, for the part of the amount, it is valid. But if the person gives a written promise to pay a time barred debt, it's a valid contract. Again, in the case of an agency, generally, obviously, if someone is doing the work for me, I have to pay him. No one will do the work for me free of cost. Please, no one will do the work for me for free of cost. So, generally, when someone does the work for me, I have to pay him consideration. But what the act is saying here is that, let's say I hire an agent, okay, or let's say someone does the work for me and I don't pay any money. The best example is an active partner. He is not paid any remuneration. He is the agent of the other partners. He is not entitled to get remuneration. But the agency is valid or not? Absolutely valid. So even if I don't pay any remuneration to my agent, the agency is still valid. So I am not saying you must not pay remuneration, but even if you don't pay remuneration, it is valid. So no consideration is required for an agency. That means for an agency, consideration is not an important criteria, right? For an agency, consideration is not an important criteria. Then completed gifts. What do I mean by completed gifts? If I just say gifts, it could be just a mere promise. If I just say gifts, it could be a mere promise. But when we say completed gifts, it means it's not just a promise, but the gift is given, right? When we say completed gifts, when we just say gifts, gifts could be just you know as in a promise to gift. But when we say completed gifts, means the gift has been given. A mere promise to gift is not enforceable by law. A mere promise to gift is not enforceable by law. But if the gift is already given, it becomes a valid contract. And if the gift is already given, then you cannot demand it back. It's a valid contract. So a promise to gift is not enforceable by law. But if the gift is given, it's a valid contract. Right? A promise to gift is not enforceable by law. But if the gift is given, it's a valid contract. Now you cannot demand the gift back. Charities and donations. Promising to give charity, promising to give donation, I will give this donation to this fund, this donation to that fund, not enforceable. Not at all enforceable. But if on the basis of the promise the other person has incurred any liability, it's a valid contract. A promise to give charities, a promise to give donations is not enforceable. So if you have just promised but you don't give, they cannot sue you to give that. But if on the basis of your promise the other person incurred some liabilities, they can recover that from you. So then once the liability is incurred on the basis of your promise, it becomes enforceable and a valid contract. It can be enforced. However, if the promise is in kind, okay, the promise to pay is in kind, then it is enforceable immediately. However, if the promise to pay is in kind, it becomes enforceable immediately. Then last one, bailment. Bailment is basically the possession of the goods are transferred for a specific purpose, right? The possession of the goods are transferred for a specific purpose. Now, I am not saying there should not be consideration. In bailment, we can have consideration or we may not have consideration. Both situations can happen. And even if there is no consideration in a bailment, it's absolutely valid. So, in a contract of bailment, consideration may or may not be present. And even if it is not present, it is absolutely valid. I hope it's clear. So, I'll just give you 2 minutes, go through it. If you have any doubts, otherwise, we'll wind up for the day. Okay, chalo, is it clear to all of you? Is it clear to all of you? Yes. So I guess it's clear to everyone. So we will end today's session here and I will see you. Bailment, I'll explain again. So basically, let us say um, you have sold some goods to a person who resides in another city. So you give the goods to the carrier to deliver the goods to that person in that city, or you give some fabric to the tailor to stitch it into a shirt for you, right? Or you lend a book from the library, or you lend a book from your friend, or you are going out for a vacation, you ask your friend to take care of your puppy, or maybe you go for a dinner and you keep your car for valet parking. So all these are contracts of bailment. So you are giving the possession of the goods for a purpose, and once the purpose is attained, the goods will be returned back or disposed of. Now when you give it to the carrier, or when you give the cloth to the tailor, or when you lend a book from the library, they will not do it free of cost, they will charge you. But when you lend a book from your friend, or when you go for valet parking, or when you ask your friend to take care of your puppy because you're going out for a vacation, he's not going to charge you anything for that. So consideration is present in some cases, not present in some cases. So you are not, your friend is not going to charge you for taking care of your puppy. Does that mean that you will not take care of the puppy? Or does that mean that you can keep the puppy forever? No, you have to return the puppy back. So even though you are not getting any consideration, you still have an obligation to take care of the puppy. And once your friend is back, it is your obligation to return the puppy back. So even if there is no consideration, the contract of bailment is absolutely valid. So in a contract of bailment, consideration may or may not be present. And even if consideration is not present, it's absolutely valid. Damini, is it clear? Done? Chalo, all of you done? Anything else? Anything else? We'll wind up the session. We'll wind up the session here then. Chalo, I'll see you again soon. We'll meet in the next session in the next month. I'll see you soon. Thank you and have a good night. Thank you. Bye.